Hello and welcome back to our YouTube channel. I am Manbir and welcome to our deep dive into the legal architecture of business. Today we are embarking on the journey of a business contract, a journey that transforms a simple agreement, a handshake, into an unbreakable legally binding bond. Every successful business deal, every transaction is built upon this foundation. Over the next few minutes, we will uncover the core concepts, the essential pillars, and the strategic importance of business law in the modern marketplace. Get ready to master the blueprint of commerce. Okay, here's our roadmap for this session. We will start by establishing why business needs law, move into the definitions of law and contract, and then dedicate significant time to the 10 pillars of valid contract. This include exploring how to make a valid offer, what lawful consideration means, the concept of capacity of parties, and the crucial principle of free consent. We will also cover what happens when things go wrong, like breach of contract, and the remedies available. Finally, we will look at specific applications like the contract of sale and the rules governing the marketplace, known as competition law. This comprehensive journey will show you that a contract is not just a paperwork, it's a strategic tool. Okay? Now the question arises, why business needs law? Why is law not why is law not just an optional extra for business but a fundamental necessity? Okay, think of it this way. Law provides the operating system for modern society. Without it, trade would be based purely on personal trust, which is fragile and unsustainable. For business law provides the standard, the necessary order, and most importantly, the established methods for dispute resolution. Okay, so it gives us confidence to trade with strangers, knowing that if an agreement is broken, there is a legal framework to enforce justice. Law is the foundation that allows commerce to flourish. Now, the question, what is law? So, what exactly is law? It's a dynamic set of rules that evolves constantly with society. Okay, when we narrow this down to business law, we are referring to the branch of law governing trade, industry, and commerce. It dictates everything: how to form a business, how to run it, how to manage its transactions, and even how to close it down legally. The core objectives of business law are fourfold, like to establish a framework for transactions, to to help merchants avoid and settle conflicts, to promote an equitable distribution of wealth, and ultimately to facilitate the achievement of business goals. Okay, now come to the next, that what is contract. Now we arrive at the central concept. What is a contract? The legal definition as provided by the Indian Contract Act of 1872 is a simple yet powerful. An agreement which is enforceable at law. The word contract comes from a Latin word that is contractum, which means drawn together. It is much more than a simple promise. A promise is merely social. A contract is a legally binding relationship that creates a specific rights and obligations for both parties. Whether you are buying groceries, booking a flight, or securing a massive corporate merger, you are entering into a contract. It is the fundamental architecture of modern business. Okay, now move to the next slide, that is pillars of a valid contract. If a contract is an unbreakable bond, it must stand on solid ground. This ground is supported by 10 pillars of a valid contract. Missing even one of these pillars means the entire structure collapses and the agreement is likely unenforceable. Okay, these pillars are the core checklists that any lawyer or business person must memorize. We will now explore some of the most critical ones in detail, starting with the first essential step, the offer. Now, the first step is making a valid offer. Contract formation always begin with an offer. An offer is a proposal from one party, that is the offerer, to another party, that is offeree, expressing a willingness to enter into a bargain. But not every casual suggestion is a legal offer. For an offer to be valid, it must possess several essentials, like crucially, the offer must be clear, definite, and capable of creating a legal relations, and it must be communicated clearly to the intended party. This is the starting gun of the contractual journey. Okay. Next one is the price of a promise, lawful consideration. This is one of the most misunderstood concepts. Consideration. The law states that a promise is not legally enforceable unless it is paid for. This price of the promise is called consideration, that is, something in return. An agreement without consideration is famously termed as naked or bare promise. Some of the key rules for valid consideration include: it must move at the desire of the promiser, meaning it has to be part of the agreed exchange. It may be past, present, or future, and importantly, it needs not be adequate. The law doesn't care if you sold your car for $1, as long as that dollar was genuinely offered and accepted as consideration. Okay, so however, it must be real and lawful. You cannot promise to commit a crime as a consideration. Okay, now move to the next, the people in the deal, that is the capacity of parties. The parties entering the agreement must be legally fit to do so. This is known as capacity of parties. According to section 11 of the Indian Contract Act, for a contract to be valid, the parties must be legally competent. Who is competent? Generally, three categories of people are deemed incompetent to contract. First one is minor. Who is minor? Those below 18. Second is persons of unsound mind, and the persons disqualified by law, like enemy, aliens, or insolvents. So, if a contract is signed with an incompetent party, it is usually void ab initio, means void from the very beginning. Okay. Next, we have the meetings of mind, the principle of free consent. A contract demands a true meeting of the minds, meaning the parties must agree upon the same thing in the same sense. According to section 13, consent must be present and it must be free. Free consent means that the parties enter the agreement willingly, without any form of pressure, misunderstanding, or misrepresentation. If consent is absent or force, the contract is compromised. Okay. Now the question, now the topic is, when agreement is an illusion, means some of the factors that vitiate consent. What are the threats to free consent? The question rise. Okay, so here is a five factors can vitiate or destroy the free nature of consent, making the resulting agreement voidable by the injured party. These factors are coercion, like using force or threat. Second one is undue influence, exploiting a relationship of trust. Okay. Third one is fraud, like active deception. Hmm. Fourth one is misrepresentation, that innocent misstatement of facts. Okay. And last but not least, that is mistake, a fundamental error about the subject matter. So when agreement is caused by any of these factors, the agreement is an illusion and the injured party has legal resource. Okay, come to the next point, that is the classification of contracts. Okay, so contracts exist across a wide spectrum and can be classified in various ways. They are primarily categorized by validity, like valid, void, or voidable contracts, by formation such as express contracts formed explicitly, or implied contracts formed by conduct, and by performance like executed contracts where both parties have finished their duties, or executory contracts where duties are still pending. So understanding these classifications help define the legal status and obligations of any agreement. Okay, now move to the next slide, that is breach of contract. No one enters a contract planning to fail, but sometimes a party fails or refuses to perform their contractual obligations without a lawful excuse. This is a breach of contract. Okay, so when this happens, the journey isn't over. Unfortunately, contracts can be broken. A breach of contract occurs when one party fails or refuses to perform their contractual obligation without a lawful excuse. Okay, so when a contract is broken, the law provides a legal toolkit of remedies for the injured party. So, here is the toolkit, or we can say that the remedies for an injured party. Okay, so like first one is cancellation or recession of the contract. Second one is like monetary compensation, or we can say that damages for the losses suffered, you know. Third one is quantum merit, means as much as is earned, a claim for reasonable payment for work already done when the contract is terminated. Okay, next, the special performance. In some cases, forcing the breaching party to complete the promised act. Okay, that is the special performance. Next one is the injunction, when a court order restraining a party from doing something that they promised not to do. Okay, last but not least, that is restitution. That is the act of restoration, which requires the return of any property or money which is given by the party. Now move to the next slide, that is the journey in action, the contract of sale. The contract of sale, governed by the Sales of Goods Act 1930, is a prime example of contract law in action, where a seller transferred the property in goods to the buyer for a price. It highlights a critical principle, that is the doctrine of caveat emptor, meaning the let the buyer beware. There is also an implication that the buyer is responsible for examining goods to ensure suitability. The seller is typically not liable for defects the buyer could have reasonably discovered. Okay, discovered. But note, this rule doesn't apply if the seller commits a fraud, or if goods are sold by sample or description. Okay, now come to the next point, that is the competition law, the rule of the marketplace. Finally, let's quickly look at the big picture. Competition law, the Competition Act 2002. This law is designed to promote healthy competition, protect consumers, and ensure freedom of trade. It focuses on two key prohibitions. First one is anti competitive agreements, cartels like fixing prices, controlling production, or ragging bids are strictly prohibited. Second one is abuse of dominance, which covers under section 4. While isn't while it's not illegal to be a dominant player, it is illegal for a dominant company to impose unfair conditions, okay, limit production, or deny market access to others. Got it? Okay, so we have traveled from a simple handshake to a complex, legally enforceable agreement. The final takeaway: understanding business law isn't about memorizing rules, okay? It's about mastering the tools to manage risk and conduct commerce with confidence. A well crafted contract is the blueprint for a successful transaction and your first line of the defense when challenges arise. So, here we can conclude our lecture with the quote that master the blueprint and you master the deal. Okay, now we conclude our session here. If you found this helpful, please like and subscribe. Thanks for watching.